Hi, everyone. First, I want to take the time to say thank you to all of you who have supported our efforts with House Bill 508 here in Ohio. The calls, the emails, the meetings, all of the sharing of the status updates regarding House Bill 508. Thank you so much for your support. We couldn't have gotten this far without you. And I also think it's a good time to give you an update on where the bill is and where we're going moving forward. So if you don't know, House Bill 508 was introduced last December, December of 2021. So it's been exactly a year. And it's the Children Need Both Parents Act, or Ohio's Equal Parenting Bill. And it was introduced by two primary sponsors as a bipartisan effort. So we had Representative Rodney Creech, who's a Republican, and we had Representative Thomas West, who is the Assistant Minority Leader. And these two gentlemen came together because they really do believe that children deserve to have access to both parents when parents are no longer together, and that children really benefit from having that influence from each parent. And family courts need reform in Ohio. Now, that was not a tough sell. They were able to actually get 59 additional co-sponsors for the bill. So 61 out of Ohio's 99 representatives came on board as co-sponsors to support this very important piece of legislation. Um, in February, it was assigned to the Civil Justice Committee. We were a little nervous about that because there are a lot of members of the Civil Justice Committee who are members of the Bar Association, and historically, other states have had a lot of opposition from the Bar Association, and we anticipated the same. So we were a little nervous that there were so many members of the bar that were on the Civil Justice Committee. But at the same time, a majority of the committee were also co-sponsors. So we felt like, okay, so they're members of the bar, but they're also co-sponsors on the bill. So we know that they believe in what we're trying to do. And so we were very hopeful going into committee. Over the next few months, we had 6 hearings. So we had opportunity to provide proponent testimony. We were able to bring in experts and researchers who have spent their entire careers researching into parent-child relationships and child development and well-being. And so they were able to come and testify with their expertise. We also came and presented data and research. There's over 40 years of research that demonstrates children really do best with two parents equally involved in their lives, and that across all metrics of child well-being, children raised equally between parents when parents live apart do better, significantly better than children who are raised in a sole custody situation. So we know that the research is there. The legislators were very supportive. Ohioans were supportive. In 2018, NPO polled Ohioans, and we know that 87% of Ohioans believe that children should have equal access to both parents when parents divorce. So we know it's a good cause, and we know that it's the right thing to do for Ohio's families. But in order to get there, we have to completely reform family courts, and that's what HB 508 does. So we had the opportunity to present our testimony in favor of the bill, and then opponents also had their opportunity. And so the people who came out in opposition were not a surprise to us. The judges came out very hard. The Ohio Judicial Conference, that's the Association of Judges, they came and testified against the bill. The Bar Association came, or they sent representatives from the domestic relations or family law portion of the Bar Association. They came out and testified against the bill. We also had some advocacy groups and domestic violence groups who are against an equal presumption. The Child Support Enforcement Agency also came out in opposition. None of those were surprises to us. So we were, interested to see how things would go from there. So after all of the hearings and during, there were a lot of meetings happening behind the scenes, a lot of interested parties meetings. And that's where lawmakers try to get the different groups to come together and discuss legislation and maybe hopefully come to an agreement or negotiate terms or get on the same page. And so we had a lot of those meetings. We met with the bar, we met with the Ohio Judicial Conference, we met with the domestic violence groups, we met with the Child Support Enforcement Agency and the Association of Social Workers. We met with all of these different groups, and we felt like we did make a lot of progress. But at the end of the day, they weren't going to support a legal presumption of equality. And so that wasn't something that we could really negotiate on. So those talks didn't really go further than that. The chair, who is a co-sponsor of the bill, and also the floor majority leader, who is also on the Civil Justice Committee, told the representatives that really to move the bill forward, they're going to have to negotiate big time and they're going to need to lower the evidentiary standard. So what we were proposing was that in order for courts to deviate away from an equal presumption, that there would have to be evidence that that presumption would be detrimental to the child, right? We don't want the courts going in and separating a good parent from their child just because they have to pick a custodial parent in Ohio. But we wanted there to be evidence, like there needed to be legitimate reason why this parent should not have equal access to their child, and that the standard of evidence for that would need to be clear and convincing evidence, which is higher than the current standard. So right now, in civil courts, domestic relations courts included, the standard of evidence is the preponderance standard, which is a more likely than not scenario. It's well below what most of us know about court, the beyond a reasonable doubt standard that you see in criminal court. The preponderance standard is way lower than that. And I think that's a big reason why we see so much litigation and so much mudslinging, so many false allegations, and why divorces get so nasty is because the evidentiary standard is so low that they really can't admit almost anything. And at the end of the day, the judge doesn't have to be convinced about anything. They just have to pick someone to believe. So when you have a he said, she said situation, they just have to pick someone, and it's not based on real hard evidence. And we think that's a problem. So we wanted clear and convincing evidence. The bar and the judges adamantly opposed that standard, and basically told us through leadership that get rid of clear and convincing and we'll back down. So the representatives agreed to do that, and they took the standard down to preponderance of the evidence standard through a substitute bill. So there is a sub 508 now. And that was all done in May. And then at the very, very last hearing, which is the last time there was a hearing for the bill, right before summer break, the chair directed the representative from the Bar Association to work directly with LSC at that hearing. And if you don't know who LSC is, it's a Legislative Service Commission. They are the nonpartisan agency who actually drafts legislation. Like they finalize the language, they research bills, they analyze them, they do comparative analysis. They're just kind of like the research arm of the legislative process. And they also make sure that everything is still constitutional that you're proposing. They make sure that your bill isn't conflicting with existing law, all of that. They're basically attorneys, but they're nonpartisan attorneys who write and draft legislation. So the chair of the committee instructed the bar guy to work with LSC over the summer on some language. And that's the last we heard. So here we are, now it's December. We have not had another hearing. The General Assembly ends at the end of the year. We just had elections. So in January, all of the newly or re-elected officials will come back to the State House and start a whole new General Assembly. And any bills that didn't make it through this session, they die. And in order to proceed, you have to reintroduce them in January. So as of now, that's the plan. It hasn't made it out of committee, so it obviously still has a long way to go. But we're not giving up. The representatives are certainly not throwing in the towel. They're very energized. We have a lot of support at the State House. I even had a conversation with the governor myself and mentioned the bill, and he agreed that it is time for Ohio to reform family courts. So we know that this is going to be moving forward, and we cannot let up. I know it's discouraging that it didn't make it out of committee, but it's also not super surprising. But it's very encouraging because what it did was kind of set off the alarms. The judges and the Bar Association, they are awake now, and they are very motivated to do something, and whether that's fighting us or doing something else, family court reform is here. And we need to make sure that we are still here going into the new year and ready to go. The thing that surprised me the most, I think, was not that the judges were against it. And when I say judges, I don't mean every judge. I mean the Ohio Judicial Conference, which is like the association of judges. They formally came out in opposition of the bill. They sent representatives. We met with them in private. Like, they do not like the bill. But what surprised me was that they're so involved in the legislative process. And that was really eye-opening to me because judges are writing legislation. 508 got them to finish a bill that the Ohio Judicial Conference team has been working on for many years. And when 508 came out, they all scurried to finish drafting their own bill for family court reform. And that bill, that draft, is not a bill, it hasn't been introduced, so it's not a bill, but it's a draft of a bill. It's a piece of legislation that has been drafted, and they are shopping around right now to senators and to representatives to get one of them, or many of them, to introduce their bill. So you have judges not only formally coming out in opposition or in favor of bills, you have judges not only making the trip to the state house to testify in a hearing in opposition to a bill or in favor of some bills, you also have judges writing their own legislation and shopping around to legislators to introduce their bill. Now, I don't know about you, but I find that a little bit problematic. So I do not intend to stop. I do not intend to back down. We're going to go into the new year ready to go. Ohio families need this. Ohio families want this. The solution we're providing is the best solution to help decrease litigation and to make the divorce and separation and custody dispute process much easier, leveling the playing field. I mean, when you take out the incentive to win custody, parents are not going to fight as hard. It's going to be a much easier process. People fight when they feel like there's something to lose. If there's nothing to lose and you have a chance at raising your children, you're going to cooperate a lot more than you do when there has to be a winner and there has to be a loser, which is how it is currently in Ohio. So stay encouraged. We have made a lot of progress this year. We have ruffled a lot of feathers. The legislators are supportive. Ohioans are supportive. We have a long way to go, but we've also come a long way. I mean, this is the first bill that's been introduced like this in a very long time. We made a lot of progress. We've gotten further than anyone ever has, and it's only up from here.